Okay, I want to thank you for joining us today. This is a really important topic. I want to tell you, I've had a number of situations in my career, and one I'll explain later, where I actually had a client who did not take my advice about whether or not, in his hiring somebody to help his sister as the conservator here, whether or not the person was an independent contractor or an employee. And what ended up happening is it cost the client $65,000, and I do have an email from them basically saying I should have taken your advice, and the answer is yes. This is, one thing when we're dealing with persons with special needs here, whether it's the Golden State Pool Trust or or it's a private trust or whatever. Caregiving, probably after housing, is probably the largest issue that we deal with. This is commonly misunderstood here, and I will tell you, it could be a really serious issue, not just for the trustee, but also for the attorneys that are doing counseling in this area. Now, this is going to really build a lot on what Rachel Green had talked about here, and we still have that video here talking about from their perspective and how they work. Here about dealing with employees of special needs trusts and that kind of thing. But Robert, who I met you the first time about a couple of months ago, and I was really impressed by the presentation up in Modesto here. And so I was really impressed by Robert's presentation. So I asked him to come today to really cover more on the whole issue about employees of special needs trusts and employment issues and how important this is. So let's go through the introduction here. Robert Nettleman, not to be mistaken for Nettleman here, is the owner and primary attorney of Nettleman Law Firm. He represents individuals and companies in federal and state courts and various administrative agencies. A significant focus of his practice relates to wage and hour claims, breach of contract, trade secret protection, claims for sex, race, and age, pregnancy discrimination, and harassment and accommodating persons with disabilities. Okay, a major focus of his practice includes advising caregivers, agencies, trustees, conservators, family residential care facilities, care homes, and others regarding wage and hour employment laws in the elder law and special needs industry. I will tell you, as a member of PFAC, he is a favorite on the listserv. So if you put anything about wage and hours, he almost certainly is going to pop up here. So anyway, I'm really excited about having him here today and talk with us. Now, as always, Amy is watching here for any questions you might have. And so when we get to the end of the formal presentation, Amy will be, once again, relaying those questions to Robert here. The last thing with this is this program has been approved for 1 unit of MCLE credit by the State Bar of California. Who knows, we may be able to edge this up to 1.5 units here. Once again, this is from the North Bay Housing Coalition, which is the nonprofit here that oversees the Golden State Pool Trust. There will be 3 codes throughout the program. So in order to get MCLE credit, whether you're an attorney or you are a fiduciary, what you need to do is email Amy at gSPT.org. That's AMY@gSPT.org. And she will send you the proper forms to fill out, but you absolutely will need the 3 codes, which Robert will read throughout the presentation. With that, here, Robert, I'm really excited about you presenting to our folks today here, and let's see what you've got to say.
Okay, thank you very much, Steve.
Okay, fantastic.
So my first foray into kind of caregivers and the elder care industry, I've been doing employment law for 20 plus years, and I had a colleague who was having some issues with their caregiver. My colleague was the attorney who was representing the conservator. Actually, I think she was representing the trustee, but there was also a conservator of the person. And they decided that the caregiver who had been working for them for 10 plus years was not working out. for a number of reasons. One being she moved her entire family into the home. Mom was locked away up in the upstairs bedroom, hardly ever coming out. And the caregiver was apparently in a personal relationship with the successor trustee who was creating all sorts of problems. So the conservator and the trustee decided it was about time for this caregiver to go, brought me in, and we sat down and we looked at some of the issues. And as far as getting the caregiver out, terminating her employment, and getting her out of the house, that wasn't too big of an issue. But one of the issues that came up very early there that I spotted was they were paying this person as an independent contractor. I believe they were giving her a 1099, but it was still no taxes were being withheld. And they were paying a flat rate. They were giving her a certain amount of money each month, plus she got free room and board. Well, the problem with that is the law doesn't allow you to pay salary to what we call a non-exempt employee without paying overtime. When we sat down and did the calculations, assuming this gal was going to claim that she was working 24 hours a day, 7 days a week for the 3 to 4 years that she could go back and claim, we were easily looking at about $350,000 potential liability. Thankfully, we were able to get things resolved. There were some hiccups here or there, but that was kind of my first foray into, wow, this is kind of an represented area where there are a lot of families, particularly as people are aging, a lot of families who need in-home care, people in special needs trusts that need in-home care, and how to do it correctly. Back in the old days, it used to be a lot of independent contractors, friends of the family, as we're going to discuss in a moment. Many new laws came into effect, different court decisions that really changed the landscape and how that all works. So I believe the first thing I do, the first MCLE code, just so you can all have that, is 5820. So if you want to receive MCLE credit, please please enter that 5820 code into the computer so that you can get your appropriate credit. Again, 5820 is the code. We're going to talk a couple of different steps here. We're going to talk about, first of all, who can be responsible or liable for some wage and hour issues. We're then going to move into how the definition of employee or definition of employer has changed over the years, and talk a bit about a new law that a lot of people are aware of that's coming into effect January 1, AB5. How is that impacting and what things can we do under there? And then we're going to go into some kind of wage and hour basics, minimum wage, overtime, some do's and don'ts, so people can approach this with the best intentions and doing it correctly and avoid liability. So who can be liable for wage and hour mistakes? Well, it all goes back, 2010, there was the case Martinez v. Combs. And in that case, there were a group of workers who were working for Mr. Combs. Mr. Combs was a strawberry farmer. He would grow the strawberries. He'd hire the people to come out, pick the strawberries, put them in baskets or into the containers. And that information, or those strawberries would then go to other people who would be selling them to the markets. Well, Mr. Combs ran into some financial problems and wasn't able to pay all of his employees. So a group of employees got together, hired some attorneys, and they decided to sue not only Mr. Combs, their actual employer, but also the companies that were coming out to the fields and directing the workers as far as how to put the strawberries into the cartons. They were alleging that under the wage order, these outside entities that were coming in and essentially directing the work that the workers were doing were in fact employers. And that's because the wage order, let me back up for a moment. Every occupation, every industry has at least one wage order that applies to them. And that wage order defines when they get overtime. Do they get it after 8 hours, after 9 hours, after 12 hours? And in there was a definition of what it means to employ someone. And it includes anyone who suffers or permits somebody to work, somebody who exercises control over the hours, wages, or working conditions, as well as anybody who engages or hires, thereby creating a common law employment relationship. interestingly, in the labor code, there actually was not a definition, or at least not a definition in this context, of who is or who is not an employer. So the workers were arguing that the wage order definition is the definition that the court should apply. And the courts agreed. They went all the way up to the California Supreme Court in 2010 in the Martinez v. Combs. The California Supreme Court adopted the wage order definition of employer for any claims that would involve the wage and hour of employees, certainly underneath the wage order or under the labor code. This was a pretty broad definition because, again, it included anybody who suffered or permitted somebody to work, or if they exercised control over the hours, wages, or working conditions, or if they engaged either directly or indirectly, thereby creating a common law relationship, an employment relationship. And those are all ors. They are not ands. Now, in the Martinez case, the court ultimately found that the other producers that came in and provide some direction to the workers were not the actual employers. They were not actually exercising the level of control that would be necessary to create an employer-employee relationship. Although they were providing some direction on how to properly package things, they weren't actually controlling the hours, the wages, or the working conditions. This pretty broad definition had many employers questioning, okay, well, how broad is this really going to be and in what context? The next kind of significant case that came up, particularly in the elder care industry, was the Guerrero versus Superior Court case. And that was in 2013. It was a case against the County of Sonoma. There's a program, many of you may be familiar with, the In-Home Support Services, IHSS. Under the IHSS program, persons who are disabled or who are elderly and need in-home care and who are financially in dire straits can get caregivers to come in, and the state will actually pay for that. It is administered through the county. Well, in this particular case, Guerrero was hired to perform services for a person who was disabled. She performed work for about 3 months, but never got paid. And she was hired through the IHSS system. So Guerrero sued not only the person who hired her, she also sued the person she was providing the care to. She sued the state of California because it is the state program. She also sued the County of Sonoma because the County of Sonoma was the one who was administering the program. They're the one who actually sent out the paychecks. The county also had certain administrative obligations to ensure that the work was actually being performed. The court looked at the definition of employer under Martinez v. Combs and under the wage order and decided that the joint employer would include persons that hired the caregiver, the care recipient, the state of California, as well as the county, because the county essentially controlled the purse strings. The county was one who had an obligation to be in there to make sure the services were provided, and they were often also the ones that could say, yes, we're going to pay for this, or no, we're not. So when you think about that in the context of if I am the conservator of a person or if I am the trustee of a trust, what does that mean? What does a trustee of the trust do? Well, we have to make sure that the services that are being provided, that we're actually writing the checks. We can't just write a check if the services are not provided. We are, in effect, controlling the purse strings. So there's certainly an argument that can be made that the trustee is, in fact, an employer. In fact, I'm dealing with a case right now where the trustee came in to a situation where there were some caregivers. They actually hired a care agency to provide the caregivers to the care recipient. The care agency, according to the allegations and complaint, didn't pay the employee correctly, and so the employee sued the care agency, the care recipient, and the trustee, both in her individual capacity as well as in her capacity as the trustee. Now, hopefully that case is in the process of getting resolved. I think we have very strong arguments because we didn't actually control anything. We were just the ones who were hiring an outside agency. But nonetheless, the plaintiff does have an argument that can be made that the trustee can be personally responsible as well as the trust can be responsible for the cost of this caregiver, even though they went through a care agency. I'm going to, just for a moment, I know that You had somebody from Team Risk Management recently who did a presentation. They're actually one of my kind of go-to third-party employers in the caregiver industry, and one of the reasons I really appreciate Team, aside from the fact that they understand and know what the laws are, so they're complying with the laws, they are taking on that responsibility as the employer. And last time I looked at their contract specifically says, if you as a client are ever sued as the employer, we will defend and indemnify you. And I think that's the correct thing to do, that's the responsible thing to do, and it can relieve the stress of the trustee or the conservator, because now we have this agency that is responsible and is taking responsibility for that. If you are going through an agency, I will usually recommend that we ask the agency some pretty simple questions. First, do you use independent contractors? If they use independent contractors, I do not use that care agency. Next, I ask, do you comply with all state, federal, and local employment laws? They almost always will say yes. If they say anything other than yes, obviously we're not going to use them. And finally, I ask them if they'll put that in writing. And most often they have no problem putting in writing the fact that they comply with the law. And I have a nice little paragraph that adds in there that if my client or the care recipient is ever sued as the employer, that the care agency will defend and indemnify my client. I've not had any companies that have pushed back on that. Maybe they want to change the wording a little bit. That can add a little bit extra protection for a trustee or a conservator or other private fiduciary to help ensure that the trust assets are not going to be at risk because the actual employer failed to pay correctly. So getting back into our timeline of when things happened, we had the Martinez case, we had the Guerrero case. The Martinez case got a lot more publicity, certainly, than the Guerrero case did. And then Labor Code Section 558.1 came into effect. And essentially that was California's legislature, for the most part, adopting the Martinez case. They're saying that any employer or other person who's acting on behalf of an employer who causes to be violated or who actually violates any provision regulating minimum wage or overtime, as well as a number of other sections, can be personally liable as the employer. Again, so any employer or other person who's acting on behalf of an employer who violates or causes to be violated any of these wage and hour laws can be liable as the employer for that violation. Well, what does that mean? Let's say I'm a supervisor of a company and I hire an employee, and I hire that employee to make widgets, and I decide, you know what, we're going to pay you a salary instead of paying you hourly. So, and I'm making that decision. I direct HR pay this person a salary, and I'm the one who's really controlling how that person is getting paid. Even though I'm not the one paying it, because I caused a violation to occur, we're going to assume for the moment that the person should have been paid hourly, then I can be personally liable for that mistake. It can put HR professionals at risk. It can also put conservators and trustees and other fiduciaries at risk, because if they are acting on behalf of somebody, if you consider the situation, I'm a conservator of the person, I need to hire somebody, we need to bring somebody in to provide care. Well, I'm the one who's going out there finding the right person. I'm the one in there negotiating the rates. If I do it incorrectly, because I am acting on behalf of somebody else, I can be personally liable for that. Again, that's Labor Code Section 558.1. They did add in a slight modification when they're saying you can be sued as the managing agent. The managing agent really comes from like a personal injury area where they're looking at somebody that could be responsible or could cause there to be punitive damages against somebody. So really you'd be looking at like a CEO, CFO, somebody like that who's acting on behalf of the corporation as a whole. And the reason 558.1 came into effect was because there are a number of employers that would have a corporation and they would be underfunded, they would violate the law, there would be a judgment against them because they weren't paying people correctly, and the individuals who own the corporation would just shut down that corporation and open a new one. And the only way for the employees to seek a remedy would be to prove that there was some sort of what we call alter ego, or to be able to trace the assets from the old corporation to the new. This Labor Code Section 558.1 essentially allows employees seeking certain types of wage and hour claims to bypass that whole alter ego liability theory and just go straight after the persons who actually did the hiring. In 2014, there was another pretty large shift certainly in the caregiver industry. That's when the Domestic Workers Bill of Rights came into effect. For several years, the legislature had tried to pass a similar law. The Domestic Workers Bill of Rights is the state law that applies to, we call them personal attendants, but more commonly they're known as caregivers. And a personal attendant is any person that is providing services to someone who cannot care for themselves as a result of their disability or age. And they're primarily providing, they're doing dressing, feeding, or supervising. Supervising meaning they're assisting with those activities of daily living. So when you think caregiver, typically that's going to be a personal attendant in most circumstances. Well, under the Domestic Workers Bill of Rights, they had a new definition of employer, which was pretty broad. It was somewhat modeled after the Martinez case, that it's any person, including a corporate officer or executive, who directly or indirectly or through an agent or any other person, including the services of a third-party employer or staffing agency, exercises control over the wages, hours, or working conditions of the domestic work employee. So again, we're going back to that, controlling the hours, wages, and working conditions as a test to determine, am I the employer, or can I be accused of being the employer? So again, if I'm a fiduciary, the more I am negotiating the terms of the contract, the more I am negotiating when somebody's going to work or how they're going to perform the work, the easier it is for somebody to conclude that I am the employer. Again, this specific definition really deals with domestic work employers. It deals with employees who are providing caregiving services in or about the home. It doesn't apply usually will not apply in a residential care facility. There can be an exception to that, but usually does not apply in that setting. It doesn't apply in your typical manufacturing setting. And also there are a number of exceptions to that, including people who are receiving IHSS services or getting paid, where the caregiver is getting paid, say, through a regional center or something like that. So there can be exceptions. But it is a very broad definition, kind of re-emphasizing the need to be cautious when hiring caregivers. So that gives us our history of like who can be responsible. In essence, it's if you are interacting with that employee, telling them what to do, controlling how much they're getting paid, how they're supposed to be performing their work, it's an increased chance. So I'm always recommending using a third-party employer such as Team Risk Management or others, using a care agency, preferably a reputable care agency, when the caregiver is doing, if you're going through an agency and the caregiver is not doing what they're supposed to be doing, rather than you going in there and directing the caregiver, go through the care agency. That's what you're paying them for. You tell the care agency what types of services you want and what should be happening, and it's the care agency's responsibility to ensure that happens. I'm going to move on now to talk about independent contractor or employee. Which are they? Several years ago, I joked that there's no such thing as an independent contractor in California, which was somewhat true. Even more so now, I think that it's very hard for anybody to be anything other than an employee in California. Back in the old days, we had the old rule, which was the Burello Test. There was actually several different tests, depending on who was asking. The Burello Test actually came from the California Supreme Court as a result of, I believe it was a workers' compensation claim, where, again, it was in the agricultural field. In this particular instance, the farmer was not making enough money, so he decided, he's just going to let his fields go fallow this year. And the workers they were seasonal workers, migrant workers, they'd come up every season and they'd work for him and had worked for him for years. They told him, look, what we'd like to do is we still like to be able to work, so we will tend the fields, we'll do the planting, we'll do the harvesting, we'll take care of everything. We just want to be able to use your fields to be able to do that. And the farmer said, okay, and he charged them a price to allow them to use his field. in the end, I believe it resulted from somebody getting injured. There was a question about whether or not the farmer was or was not the employer. And in that case, they ended up saying the farmer was the employer, based in large part based on their former history and the fact that they had had this relationship for a while. And the court identified a number of different factors to look at when determining whether or not somebody is an employee. The primary one is the level of control. And that's the one we hear about most frequently, is how much control am I exercising over the worker and how they are performing the work. If you think about a true independent contractor, if I bring in a bookkeeper to do my books, to do my accounting, I'm not controlling how they're doing it. I may provide them my information, I may tell them when I want them to get things done, but I'm not looking over their shoulder telling them how to do it. Or if I bring a construction worker into my house to do work, I may be telling them what I want done, but I'm not the one directing how they do or don't do their work. So the level of control is the primary concern under the Burello test. But there are a number of other things. They look at how integral is the work that this person is doing to what I'm doing. As an attorney, if I'm hiring a bookkeeper, well, sure, that's important, but that's not an integral part of the services I'm providing. If I am a private fiduciary that does accountings, well, a bookkeeper might be an integral part of the work that I'm performing. They look at how much investment does the worker have in their tools or in their business. Does the worker actually have their own separate business? Are they providing services to other people? Are they advertising to other companies and other potential clients? How permanent is the relationship? Is this something that is I'm hiring them on a per project basis, or is this something that's been going on for several years? What is the nature of the control? How do I pay them? Am I paying them on a per project basis versus an hourly basis? They also look at what is the intent of the parties, and this is many people will have an independent contractor agreement, and they will say, wait a minute, Rob, my contract says they're an independent contractor. Doesn't that mean they're an independent contractor? No. What the parties think is a factor under that Burello test, but it's a very low factor. It's not one of the higher factors. Really, the level of control is a primary test. Now, you'll compare that to other situations. The IRS has, I think, a 22-factor test, and IRS is the federal law, and it has many of the same factors that the Burello test has as far as control, the ability to make a profit or lose money, is the worker listed on the employer's payroll? Are they taking out taxes? Are they not? And then there's also the EDD test. The EDD is the Employment Development Department. It is for unemployment insurance as well as state disability insurance. It's actually one of my favorite tests. I wish that's what the courts had gone with, because I think the EDD test was probably the most straightforward and the easiest to do. The EDD had actually published a very handy pamphlet on you could just take the test, and if you answer yes to the first 3 questions, then chances are this person was your employee. And if you answered no to the next 3 questions, then chances are they were your employee. And then there are 4 other questions that kind of were what I call wobblers and could go either way. But it was a little bit more direct guidance and easier for employers to understand. But it was only limited to unemployment insurance. And there were situations and cases where a person could be an employee for wage and hour purposes, but would not be an employee for unemployment insurance purposes. Or they might be an employee under the state test, but they're not going to be an employee under the federal IRS test. So you had some inconsistencies. There was an attempt, at least in one case, where if you get a judgment in your favor in one form, that can be used as a basis to say this judgment has to take preclusive effect in these other situations. So back in the old days, we had primarily 3 tests that I was dealing with on a regular basis: the Burello test, the IRS test, or the EDD test. As the Labor Code 558.1 came into effect, and as the Domestic Workers Bill of Rights came into effect, we had to modify those a little bit. And then came 2018. In 2018, the California Supreme Court decided the Dynamics case, or the Dynamex case, depending on who you're talking to, which was a significant change in how the law was from what it was in the past. The Dynamics case, I believe it was a case dealing with truckers, and it was looking to determine whether or not somebody was or was not an employer. And the California Supreme Court adopted a new test, what we call the ABC test. And what was unique about this? Well, first of all, there was no statute or anything in California that warranted this new test. The California Supreme Court looked to a Massachusetts statute to decide that it was going to use the factors from that Massachusetts statute and apply it here in California. The ABC test in its basic form is, in order for somebody to be an independent contractor, the hiring entity had to prove three things. They have to prove all three. Part A is that the worker is free from control. We're familiar with that. It's from the Burello Test. It's in the IRS test. It's in the EDD test. So they have to be free from control and direction from the hiring entity with regard to how the worker is being performed. The B part is that the worker has to perform work that is outside the usual course of the hiring entity's business. And that, we're going to talk about in just a moment, was a big sticking block for a lot of people. And C, the worker had to be customarily engaged in their own independently established trade, occupation, or business that is of the same type of work that they're providing. So again, that part A, pretty simple. It was the level of control. How much control am I exercising? It doesn't mean free from all control, but really control the manner and how they're doing the work. The part C, that the employee or the worker has to be engaged in their own trade or occupation. Some of the cases that came after Dynamics and were interpreting that ABC test confirmed that the person actually had to have other clients, not just the ability to provide services. So if, for example, I am a barber and I'm renting a station at a hair salon and I'm providing my barbering skills, obviously you can see I do a great job of it, I would, unless I actually have clients outside of that salon that I am servicing outside of that salon, there's no way under that ABC test I could be an independent contractor. But even more specifically, that B factor, that is the worker performing work that is outside the usual course and scope of the work that the hiring entity does, there's no way I was going to pass that. And it had very far-reaching implications. A common situation, say attorneys, for example, we routinely will hire somebody to provide, to maybe assist with the motion or maybe make a court appearance on our behalf. Well, under this ABC test, because I'm hiring another attorney to do work that's within the course and scope of what I usually do, that person is an employee. Now, employee for what purposes? There were several other theses, again, after Dynamics that tried to figure out, well, how broad is Dynamics? The original case was really dealing with, their holding was somewhat limited to cases brought under the wage order. Without getting too much in the weeds, hopefully, the Dynamics case said, yes, the Martinez that we talked about in the beginning, that is true. It's still whether or not you suffer or permit somebody to work, whether or not you control the hours, wages, or working conditions, etc. But they were not happy with what does it really mean to suffer or permit somebody to work. And this ABC test was the court's attempt to interpret that suffer or permit. So, again, technically under the wage order, you are an employee if you meet this ABC test, or if you control the hours or wages. They control the hours, wages, or working conditions of the employment. So it's a multi-factor test. The difficulty that everybody was having again was how can I ever hire somebody that's outside my course of employment? Again, it's easy if I'm looking at the plumber or the accountant and I'm having them come in to do some work. But if I'm hiring, if I'm in a staffing company and I'm hiring, or I'm a Google and I'm hiring a staffing company to provide a worker, and that worker is doing the same work as everybody else, under the ABC test, they're going to be my employee. The court cases were pretty good afterwards, limiting the impact of ABC to only questions under the wage order. What are questions or claims under the wage order? Claims for minimum wage, overtime, missed meal breaks, missed meal periods. The Dynamics case specifically held that claims for unpaid expenses, which is under the labor code, not under the wage order, that those would likely be a different test. They didn't identify what that test was, but they said that issue wasn't before us, so we don't have to decide it at this time. So it left open that there may be some cases, some claims where you're an employee, some where you're not. Led to at least one case where the court decided there were multiple claims, including a wrongful termination case, an unpaid wage claim, etc. And the court applied the ABC test for the wage portion, but a different test for the discrimination case. So you can have the same individual providing the same work to the same employer, and in the same lawsuit, they are an employee for some claims and not an employee for others. So the industry was up in arms. They thought this is a terrible thing. We don't want to have this. It's too far-reaching. Many employers complained. At the same time, you had employee groups who wanted to expand the ABC test to areas outside of just the wage order, because persons who are independent contractors generally are not entitled to the same protections that employees are. Independent contractors are not entitled to overtime. Independent contractors don't get reimbursed their expenses. They may be able to write them off, but they don't get reimbursed those. Independent contractors aren't entitled to get paid at least twice a month. Independent contractors aren't covered by workers' compensation, usually. Sometimes they will, but usually they're not. So there are a lot of employee groups that wanted to expand the ABC test so that it would apply to as many employees as possible. At the close to the last hour, the legislature passed what is now known as AB 5, and Governor Newsom signed it into law. AB 5 is the new law that will go into effect January 1. I've spent a lot of time analyzing AB 5, and it is a very complicated statute. I think it's something like 190 paragraphs long. It has exceptions to exceptions and several different rules. We're going to kind of go through some of those rules today. In some ways it is good because it provides clarity for some things. In other ways it's really bad because one of the main things it does is it applies this ABC test not just to claims under the wage order, but now any claim under the labor code, as well as for purposes with the Employment Development Department for unemployment insurance. So it is expanding that ABC test to a number of other claims and areas. That's the kind of the bad part from an employer perspective. From the employee perspective, it's great. It means that there's a greater chance that I can be somebody's employee, and I will have more laws that will protect me from employers who would try to take advantage of me. The bigger issue I see with AB 5 is there are so many exceptions to the rule that to some degree it swallows it up, and it makes it an overly complicated method. The way ABC is written, or AB 5 is written, the ABC test is the default test for any claims under the labor code or for unemployment insurance and any claims under the wage order. If you meet one or more of several different exceptions, which there's a test to see if you meet that exception, then the Burello test that we talked about earlier is what's going to apply. So in essence, depending on where you fit, we're going to have to do one test to see if a second test is going to apply. I refer to AB 5 as the employer lawyer's retirement account because it's really assuring that employment lawyers are going to have a lot of business on both sides, whether you represent employees or employers, for quite some time, because I've been doing employment law for over 20 years, and it is a very difficult statute to understand and digest. I've created charts, Venn diagrams, flow charts, all sorts of things to try and get a better grasp on which exceptions apply and when. This is a good time to let everybody know the new MCLE code. Please enter this in. This is the second time you're going to have to enter this one in. The code is 0486. If you want to receive MCLE credit, whether as an attorney or as a fiduciary, you do need to enter that code 0486. I'm going to leave that up there for a few more minutes as I continue talking. Again, that code at 0486. So AB 5 will come into effect January 1. I'm receiving a lot of calls now from a wide variety of industries trying to get an understanding of when is this going to work, when is it not going to work, when is it going to be applicable, when is it not going to be applicable. We're going to try and go through some of the major exceptions. Some of them are going to apply in your business or the people you're doing work with. As is normal, one of the first exceptions that people have is for certain professionals, attorneys. Attorneys are accepted from the AB5 test, as well as other people licensed by the Department of Insurance, architects, engineers, private investigators, accountants, physicians, what I call the higher level professionals. Usually they are people that are licensed by the state. It does also include securities, brokers, and dealers. Interestingly, direct salespersons and commercial fishermen are also made the list. Direct salespersons are the door-to-door salesmen. They're the people who are selling directly to the consumer, again, usually going door-to-door. Commercial fishermen, I'm not sure how they made it into this list of exceptions. They must have had better lobbyists. Some of the workers that did not make it, the trucking industry had a large lobby trying to get their drivers to be exempt from the ABC test, as did musicians and persons in the performing arts. They did not make the list. The next major exception are contracts for professional services. You may be thinking, oh great, I'm a professional, so if I have a contract with somebody who else is a professional, that means that the ABC test does not apply. Unfortunately, that's not true, because the contracts for professional services is limited to 7 specific industries. It's people in marketing, enrolled agents who are licensed by the Treasury, payment processors, so your paychecks or your ADP, still photography and photojournalists, assuming that they don't provide, I think it's more than 35 pictures per year. Freelance writers and editors of newspapers or newspaper cartoonists. Again, you're limited on the number of submissions. So if you do 36 submissions a year, you're an employee, but if you do 35, you're not, which can be a real big problem if I've been treating you as an independent contractor for 35 submissions, and then you do a 36th in the year. Now all of a sudden I have to backdate everything and you become an employee, is a potential issue that could come up. The other one, which is somewhat limited, are persons such as estheticians, ectrologists. I always mess up that word. People are doing the hair removal. Manicurists, barbers, and cosmetologists. The manicurists, there is a sunset clause, and there are specific provisions for them, a little kind of subcategories and tests that they have to provide. So that contract for professional services is really limited to those specific industries. If you are in one of those industries, or you're hiring somebody in one of those industries, you still have some sub-tests that you have to provide. Many of them are similar. The main parts of the test are the worker has to have their own independently established business. They have to be providing services to other clientele. They have to hold themselves out that they're doing so. They have to have a business license if they're performing the work in a locale or an area that requires a business license. They have to be able to negotiate and set all their own rates for the services, and they get to set their own hours. They can be subjected to certain business hours. Hey, we're open from 8 a.m. to 8 p.m., but they get to decide when they're going to come in and when they're not. For the estheticians and the barbers, etc., they also have to be able to decide whether or not they want to accept particular clientele or not. I'm assuming most of the people on today's webinar are not hiring a lot of barbers, possibly some enrolled agents, but we can go into that test. If people have some specific questions, we can go into that in a little bit more detail. Another one that is kind of a big category is for a referral agency. A referral agency is a company that is just referring people out. And you'll see this in the caregiver industry. There is actually a domestic work referral agency statute that has some specific requirements where all I'm doing is I am connecting A and B. I'm not controlling how much they're getting paid. I'm not the one who's the one who's controlling when they're going to get paid or even what work. You come to me saying, hey, I need somebody to perform X work. I am providing you a referral of 1, 2, or maybe several different possible workers, and then leaving it up to the two of you to decide if you're going to work with each other, and then I usually get paid some gratuity or percentage or a flat fee for those services. Again, there are only specific industries that can take advantage of this referral agency exception: graphic designers, photographers, tutorers, event planning, some home repair, moving, home cleaning, home errands, furniture assembly, which again, I don't know how that got in there, animal services, including dog walking and dog grooming, some web design, picture hanging. Leads me to believe that there's a big picture hanging mafia out there. I don't know, they've got a good politicians in their back, I guess. Pool cleaning and yard cleanup. So again, not the typical services that most of the people attending today's seminar are really going to be using. It does give you that if you're hiring a web designer to do your website, they're not necessarily going to become your employer. Or if you are hiring somebody to provide services to somebody with a special needs trust, to come in and do some yard cleanup or to run a few errands, that is still possible. They could be considered an independent contractor. Now, had you asked me that question 2 years ago, I would say no, there probably are going to be employees. But now with the AB5, it is possible if I have somebody who's coming in and just doing some pet sitting or pet grooming, that they could be an independent contractor. Same type of rules are also going to apply in the sense of the person providing the services has to have their own business. They're going to have a business license. There's going to have to be a contract that says that the person is free from control, and that person actually has to be free from control. They're going to be able to set their own hours. They're going to control how they're doing the work. It harkens back a lot to what we were talking about, the Burello Test, the sense of control. The person is free to take on the assignment or not. Again, if you have an issue dealing with the referral agency, then we can dive into more detail on that specific exemption. The exemption that's probably going to apply in most situations that I'm going to see, or at least I'm going to say that where I'm going to see most employers or hiring entities try to use is what we call the business-to-business contracting. And that involves a relationship between two different businesses. Business does not necessarily just mean a corporation. A business can be a sole proprietor, it can be an LLC, it can be a corporation. I think you are safer if you are doing business with a corporation rather than a sole proprietor, but the statute specifically says that a sole proprietor is in fact can be considered a part of business-to-business contract. And again, our goal is if we meet this test, this business-to-business contracting exception, then we're going to be applying the Burello test rather than the ABC test. And what we're looking at is the person you're hiring has to be providing services to you, not to your customers. I see like care managers, for example. I have a number of clients that hire care managers to come in and provide care managing services to their clients. One of the questions we have is whether or not, if I'm hiring you to come in and go observe my client and then report back to me so that I can make decisions, are you providing the services to me or are you providing the services to my client? I certainly think if I hire you to go in, observe what is happening with my client, and then talk with the caregivers and talk with the family, and I'm telling you to be the one who's providing the advice to the family and the caregivers on how to do things, chances are you are providing services directly to my client, and therefore you would not meet this exception of the business-to-business contract. You have to be providing the services to me. There has to be a contract that is in writing. If you're in a jurisdiction that requires a business license, then you should have the person I'm hiring has to have a business license. They have to be engaged in their own independently established business, so they actually are providing the services to other entities. They advertise. I'm not their only client. I guess kind of a good bright line rule is if I am your only client, then you are my employee, period. I have the person I'm hiring has to be able to negotiate their own rates. They have to be able to set their own hours. I can give them, again, some general hours. Hey, we're doing the work between this time frame and that time frame. But in general, you get to determine which hours you're going to be showing up. Also, in order to meet this business-to-business contract, they can't be performing work that requires a contractor's license. Persons with a contractor's license actually fall with one of the other exceptions. There's a specific labor code section that has and always has had a special definition for who is or is not a contractor for independent. If you have a contractor state license for it. That's where I'm going to see. I think we're going to see a lot of litigation under this business-to-business contract. I think we're going to see a lot of situations where we have a contract that says, oh, they have their own separately established business, but do they really? I mean, if they're not really providing services to other people, are they actually advertising? So what am I advising my clients? If you're going to take advantage of this, one, we need a written contract. Technically, I think the contract should come from the person who's performing the services. If you think of it as I'm hiring a plumber, when was the last time you had a plumber come into your house and you handed him the contract that he's going to sign? No. They hand you the work, or the invoice or the work order that says what the terms and conditions are. They're the ones providing the contract. So usually the contract should come from the service provider. There are a number of factors that we're going to want in there. I'm not going to want to be exercising control over how they're providing the services. I'm going to want to see, do you have a business license? I want to see your business license. Do you have insurance? I probably also want to see what kind of advertising are they doing. Are they at least advertising on Facebook and Yelp and Craigslist, Nextdoor.com, other things that maybe are low cost, but they're at least advertising? And I would probably even keep a copy of those advertisements just to be safe. We're going to see a lot of litigation over who is still an independent contractor, who is not. Is AB5, there's going to be attempts to modify it. There's already a number of different industries. I know the music industry, performing arts industry, the trucking industry. I know Uber and Lyft. We're trying to create something for the gig economy to get exceptions to the AB5. All of those failed on the first round through. We're going to have to see what changes come in 2020, 2021, whether or not some of those other modifications are going to make their way in. So, with all these rules, with Burello and Martinez and Guerrero and Labor Code 558.1 and now with AB5, we're seeing a narrowing of who can truly be considered an independent contractor. What I can tell you is the conservative approach is you treat everybody as an employee. If you treat everybody as an employee and you pay them as an employee, you can rarely go wrong. You're not going to get in trouble because you consider somebody an employee, assuming you are following all the other myriad of California laws and federal laws, and now state and local, city and county laws that apply to employment law. So we're going to go now, and we're going to switch over and we're going to talk a little bit about some of those basic wage and hour laws. This is now your MCLE code number 3. If you are intending to get MCLE credit, either as an attorney or as a fiduciary, put in code 6930. Again, that code is 6930. You'll need to enter that in there so that you can get your certification. I'll leave that up there for a few more moments. We're going to switch and we're going to talk a little bit about some of the basic wage and hour laws and some of the things that employers can do so that we don't make mistakes in the first place. And one of the first things we talk about is exempt versus non-exempt. Who is exempt and not? When I say exempt, what does that mean? Exempt means they are exempt from the overtime laws. The starting point is all employees are entitled to overtime under both state and federal law unless the employee meets a specific exemption. And it is the employer's burden to prove that the employee meets one or more of these specified exemptions. For the most part, we usually see 3 major exemptions. It's the executive, professional, and the administrative exemption. There are other ones. There's a computer software programmer exemption. And right now I'm talking about state law, and I'll explain that in a moment. The computer exemption actually is one where somebody can actually be paid hourly. And then there's weird ones that you don't think about, like sheep herders and ski lift operators and camp counselors that I've never come across. I did come across an irrigator once. They are exempt from overtime. Those exemptions are all set forth in the wage orders that we talked about before. The main ones that we see, though, are dealing with the executive, the professional, and the administrative exemption. In order to be exempt from overtime, and this is both under state and federal law, the employee both has to get a salary of a certain amount, and they have to meet certain duties. They have to be performing exempt duties. And federal law sets the bare minimum. Under the Fair Labor Standards Act, it says employees have to get paid, I think minimum wage now under federal law is about $7.25 an hour. They have their own test for who is exempt and who is not. They have different salary requirements. That sets the bottom. The states are free to enact more stringent requirements as long as it's more favorable to the employee. And California is one of the states who has chosen to do so. For the most part, if you meet an exemption under California law, you're going to meet the similar exemption under federal law. There's a few exceptions, but for the most part, we're really going to be focusing on employment law, California employment law, as opposed to the federal. The salary in California, in order to be exempt under the executive, professional, or administrative exemptions, the employee has to receive at least 2 times the state minimum wage. Keeping in mind, California now has kind of a split as far as its minimum wage. If you have 25 or more employees, it's a slightly higher minimum wage. If you're less than 25 employees, it's a slightly lower. Right now, it's about $50,000 a year. So if I pay somebody less than that $50,000 a year as a salary, then that person is not exempt, and I have to pay that employee overtime, period, regardless of what duty. So remember back in the day when Lee Iacocca took over for General Motors and he worked for $1 and that was his salary? Technically under California law, he should have gotten paid overtime because he was not getting his minimum salary. I'm sure the attorneys figured out some way around that. So what is a salary? A salary means they are getting the same amount regardless of how much they work. So if I work 20 hours a week, I'm going to get paid the same salary as if I work 100 hours a week. So there's not going to be any deduction. That's the other thing. If I want you to be exempt, and I pay you a salary of $50,000 a year, but you only worked 20 hours this week because you wanted to go to the beach, or because you came in for only 2 or 3 hours a day, and then you had some family obligations, I may still be obligated to pay you your full salary. And if I don't pay you the full salary, then you will not meet that exemption, and you should be getting paid overtime. The salary test is fairly easy to meet. Again, just pay them the same amount, make sure you're paying them enough. The duties test is where more employers run into problems. I want to first talk briefly about the professional exemption. The professional exemption is fairly straightforward because there are, I think, 7 specified exemptions. You have to be in one of these, 7 specified professions. You have to be in one of these professions in order for the professional exemption to apply. So that would be attorneys, I believe it's accountants, doctors, I think engineers, and there's a few others. It's written down, so I don't have it memorized. I apologize. There's usually not too much dispute as to whether or not somebody is licensed under one of those exemptions. Again, it is a licensed person. There's a subset of that, which is the artistic or learned exemption, where if you're in a field, in the arts field, such as a writer on a sitcom, or an artist, a painter, a sculptor, you could meet that exemption. And the learned exemption is where somebody has a higher degree, usually something above a bachelor's, so you're looking at least a master's or a PhD, and it's in a specific field of science or learning, they can sometimes meet that exemption as well. I don't see too many disputes usually over that professional exemption. Occasionally we'll see it under the executive exemption. The executive exemption applies to somebody who really is the head of a division or department. They have to supervise 2 or more people, and they have to have the authority to hire and fire. It doesn't mean the person actually has to do the hiring and firing, but if I want to be exempt under the executive exemption, I need to be able to tell you, hey, I really think we should hire this person, or I really think we should fire this person, and what I say is going to carry a lot of weight. If I am not supervising at least 2 or more employees, then I would not be exempt under the executive exemption. even if I have a fancy title such as CEO. Titles is an important thing, but not when it comes to wage and hour, whether or not somebody is exempt from overtime or not. The title really means very little. What we look at is what is the work that they are actually performing? What does the employer expect them to perform, and what are they actually doing? If I am the CEO, but I spend most of my time cleaning out the closet, I am likely not going to be exempt. The final exemption is the administrative exemption. That's probably the most misunderstood exemption and the most problematic for a lot of employers. It's one where the California Supreme Court itself has flip-flopped back and forth on positions, what is exempt, what is not. Employment attorneys can argue about that one all day long, and so employers obviously make mistakes. The administrative exemption is you're not a professional, you're not a CEO or a CFO, but you're usually you have to be reporting to some other exempt employee. So I'm reporting to the CEO or the CFO. I like to see it as kind of like a VP level or higher usually. And I'm doing projects under very little supervision. I am spending most of my time exercising discretion and independent judgment about matters of consequence. In fact, all three of the exemptions, the professional, executive, and administrative exemptions, all require me to spend most of my time performing exempt duties. And this is one area where state and federal law differ. Under federal law, they look what is the employee's primary duty. In California, they look at what is the employee primarily engaged in. And here is a real-world application. I am a manager at McDonald's. My job is to hire people, fire people. I'm supervising everybody. I'm in charge of figuring out what food. I'm in charge of doing the scheduling. I am 100% responsible, but I'm also understaffed. So I'm also spending a lot of my time actually flipping burgers, running the drive-thru window, doing the cash register, picking up cigarette butts in the parking lot, and even cleaning up the bathrooms as necessary. In fact, I spend most of my time doing that lower-level stuff. Under federal law, because my primary duty is to perform those exempt duties, I would still be exempt. Under California law, because I'm not primarily engaged in doing the exempt duties, I'm not exempt and I'm entitled to overtime. So the exempt employee has to spend more than 50% of their time performing exempt duties. They're doing the higher level stuff. Your HR professionals, your VP of HR, your president of this section, or general manager, they're making decisions of consequence. My front office staff may be making some important decisions on, should I use this copy service versus another, or should we should we get this type of supplies or the other? But those aren't really the decisions of consequence necessary to meet that exemption. Again, it is the employer's burden to prove that the employee squarely meets one or more of these exemptions. If the employee does not meet those exemptions, then the employee is entitled to overtime. I have some clients where I go in there and they have 95 or sometimes 100% of their employees are exempt. They're all being paid a salary. It's pretty rare that you would have a company where that many people are exempt from the overtime laws. Well, what is the problem if I pay you a salary and you're not really exempt from overtime? Well, primarily, the biggest problem is that that salary only compensates you for the regular hours worked and does not compensate you for any of your overtime hours. So if you were typically working more than 8 hours in a day, more than 40 hours in a week, and I'm paying you a salary, and I should have been paying you overtime, that salary is only paying you for 8 hours in a day. Now, most businesses, most occupations, that's the rule. You get overtime after 8 hours in a day, or after 40 hours in a week, or if you perform work 7 days in a row on the same work week. So for that first 8 hours. And you get double time if you work more than 12 hours in a day, or if you work more than 8 hours on that 7th consecutive day. There are different rules that can apply in the agricultural industry. It used to be that they would only get overtime after 12 hours in a day, 60 hours in a week. That is changing over the next couple of years. They're doing a graduated change. I think by 2022, they will be at the 8 and 40 rule. Personal attendants that we talked about earlier, they get overtime after 9 hours in a day or 45 hours in a week, and they do not get double time. So those are the kind of basic rules that apply for most of the workers. The other big difference on exempt versus non-exempt is the hourly employees, the people that are entitled to overtime, the non-exempt employees. They need to get regular meal and rest breaks. Really, everybody should be getting regular meal and rest breaks. But if an employee who's hourly doesn't get their required rest or meal breaks, then the employer actually has to pay a penalty. It can be a 1 hour penalty for every day that they missed a rest break, and 1 hour penalty for every day that they missed a meal break. So it can add up there very quickly. Every lawsuit that I've been seeing in the employment arena for the last probably 5 to 10 years, every employee claims they never got any rest and meal breaks. So apparently in California, nobody's ever taken a rest or a meal break. The issue is that it is something that is going to be an issue going forward, and something that people need to pay attention to. Kind of some best practices. Unless somebody clearly fits within one of those exemptions, you should be paying them hourly. Caregivers, you should never ever pay them a salary. It should always be hourly. You're not paying a shift rate, you're not paying a daily rate, you're not paying a weekly rate, you're paying them by the hour. Well, what does that mean? It means also we have to keep track of the hours worked. So what are some of our biggest, most common mistakes that we're seeing in the employment arena? Well, number one, assuming employees are independent contractors. We've spent a lot of time talking about the difference between the two. We start with the assumption that every worker is an employee. It's up to the hiring entity to prove that the worker is really an independent contractor. If they do not squarely meet that new test under AB5, they don't meet one of those exemptions, then we're going to treat them as employees, and we're going to do everything we're supposed to. The next biggest mistake is assuming that a salary compensates an employee for all hours worked. It doesn't. Unless you clearly meet one of those exemptions, I have to pay you hourly. If I pay you anything other than that, it's going to get very costly because the law says I have only paid you for the first 8 hours in a day or the first 40 hours in a week. Another big mistake is failing to correctly count the overtime hours. When do we pay it? When do we not? So under federal law, employees get overtime after 40 hours in a week. And many employers think that, oh, okay, I just have to do it after 40 hours in a week. No, in California, they get overtime after 8 hours in a day or 40 hours in a week. What does that or mean? Well, if I work 10 hours a day, 5 days in a row, first 8 hours on Monday is going to be 8 regular hours. The next 2 hours are going to be overtime. Same thing for Tuesday, Wednesday, Thursday, and now you're thinking, wait a minute, now Thursday, by then I've worked 10 hours every day, that's 40 hours. Does that mean Friday is all overtime? No. When you're counting the weekly overtime, you're only counting the regular hours worked, those first 8 hours. Because those other 2 hours that I worked, you already paid at the overtime rate, so you don't have to count those twice. So, and if I'm working 10 hours a day, 5 days a week, you'll end up with 40 regular hours and 10 overtime hours each week that you have to pay. Other mistakes that people are making is they're rounding, or they're not paying for every minute. In California, we don't have what's called a de minimis rule. What that means is if I clock in at 8:58 and I clock out at 5:02, you may have to pay me from 8:58 to 5:02. You can't round and just go from 9 o'clock to 5 o'clock. There are some instances when you can round. Your safest bet is just pay to the time that they are clocked in. If they end up working a little bit of overtime, you pay that as overtime. Failing to pay at least minimum wage for all hours worked. This comes into play a lot of situations where somebody is paid a salary because that salary only pays them for the regular hours worked. That means if I was paid a salary, I was supposed to get overtime, and I was working that 10 hours a day, 5 days a week, you've only paid me for 40 hours. There are 10 hours that not only do you have to pay me overtime, you also have to pay me minimum wage, because a minimum wage as liquidated damages because you didn't pay me at that time. And the same thing can happen when we inappropriately round. The other thing is we need to count all hours that the employee is subject to our control. This is an issue that comes up in the caregiver realm, because what do we do when we hire somebody to spend the night? And I'm hiring you for a 24-hour shift, but 10 of those hours, the care recipient is asleep. Do I have to pay you for that time? In California, the answer is yes. Federal law, the answer would be different, but under California law, if I am requiring you to be at a specific location, I have to pay you. The only way I don't have to pay you is if I relinquish all control. If I say, look, you're free to go about your business, you don't have to stay here, you can leave, you can go to the movies, you can go out to dinner, do whatever you want. Then if you decide to stay, I don't have to pay you, but it really has to be you are free to leave. And I'll see that in the caregiver industry where they'll say, well, they're free to leave, but then there's a care plan that says this person requires 24-hour care. If you have a care plan that says this person requires 24-hour care, then then the person's not free to leave unless there's somebody else there. So failing to pay at least minimum wage and overtime for all hours worked. Many employers forget to look at the wage order. The wage order should be posted in every workplace. Now, if you go through Paychecks or ADP, or you go down to Office Depot or Office Max or Costco and you get the big, huge laminated poster with all the different laws that nobody ever reads, those have to be posted in the workplace, but so does the wage order. Most employers forget to put that up. For professional services, accountants, fiduciaries, attorneys, that's going to be wage order 4. You can download that from the Labor Commissioner's website at dir.ca.gov. I can get that out, and if you reach out to me, I can send you a copy of it as well. But that has which rules apply. When does somebody get overtime? Which exemptions apply? What are the break rules? When do I have to pay them? When do I not? Those are all set out in the wage order. Take some time just to look at it, because there may be some exemptions that apply in your industry that you may not be aware of. Other big mistake, as I mentioned, is failing to track the meal breaks. The general rule is you get a 10-minute paid rest break anytime the employee works for every 4-hour block, essentially. So if I work 4 hours, somewhere in the middle of that 4-hour block, I should get a paid 10-minute rest break. After 4 hours, I really should get a half-hour unpaid lunch break. So I clock in at 8 o'clock. Around 10 o'clock, I go out and I can take my break. I can free of duty. You're not going to call me. You're not going to interrupt me. 12 o'clock, I'm going to clock out. I'm going to go take my lunch of at least half an hour. I come back in at 12:30. I clock back in. I'll work another 2 hours to say 2:30, and then at 2:30, then I'm going to take my 10-minute rest break again. That's paid. And then I clock out at my end of the day at 4:30 or 5 o'clock or whatever time is the end time. An employer does not have to track those 10-minute rest breaks, but they do have to track the paid lunch break. And they really should be clocking that starting at any time. It's not enough just to say I worked 8 hours. We should have a time in, time out, time in, time out. Because if we don't, then the employee's testimony alone is sufficient to establish the number of hours. So if the employee says, look, this does not record the actual hours that I work, we only put 8 hours and it says 8 hours every day. Well, first of all, nobody always works exactly 8 hours. There's a few minutes here where you're over or under. And so if I fail to keep accurate records and that employee later says, well, I worked some overtime, whatever that employee says is the amount of overtime is what the court is going to follow unless we can come up with specific evidence to show, no, these are the actual hours worked. So keeping track of the hours worked is the best. It can be on a time card, it can be on the back of a napkin, but it should say the start time and end times of each time. The other big mistake is failing to provide days off. Aside from the fact that people need time off, the law requires it. Everybody should be getting at least 1 day's rest in 7. There are certain exceptions due to emergencies or when you have to provide protection for somebody's property or a person, where you can kind of gather them up and set them all at the end of the month. I recommend against in the caregiver industry. It used to be popular to have one caregiver that's providing 24/7 care. They rarely get any time off. We really want to get away from that, aside from the fact that it's very expensive because you're having to pay overtime after 9 hours in a day every day and after 45 hours in a week. Really, we need people to have that time away from work where they can decompress and they can have an opportunity to recharge their batteries. You'll have much happier, healthier workers that way. And the law says you have to do And then kind of the other big mistake that I'm saying is that failing to have an on-duty meal agreement. There are certain industries where you just can't have somebody leave their post. A security guard, for example, can't leave their post for a rest break or for their meal break. For the meal break, at least, if you're in an industry that you can't allow somebody to take that meal break, you can have a written agreement that the employee signs, and they're essentially waiving their meal, or they're agreeing to work through their meal. You will pay them for that, but you don't have to pay them a penalty if they fail to take that break or if they're unable to take that break. Every other industry, if it's not an industry that makes it kind of impossible for them to take the break, then not only do you have to pay them for the time that they worked, you have to pay 1 additional hour's penalty. Again, it's a pretty narrow exception, so just because I don't want to bring in another staff member doesn't mean that I can use an on-duty meal break to get through that. So that kind of brings me through to the end of my questions that are the points that I want to cover. I didn't know if we got any questions in the time we do. Got some?
Yeah, I don't know if we'll have enough time for all of them, but
okay.
I'll hit you up with a few.
Okay.
Okay. If a worker is getting IHSS, getting paid through in-home support services for 25 hours, let's say a week, and on top of that, we hire that worker for an additional 25 hours a week, does either entity have to pay overtime?
That's a good question, and we don't know the answer, unfortunately. The great lawyer answer. First of all, you should understand you are a joint employer, because that Guerrero case that I talked about before, it says that the care recipient, the person who does the hiring, as well as the state and county are all joint employers. What that means is the hours that you work for IHSS may be counted as hours worked for me. The part that we don't know is the Domestic Workers Bill of Rights specifically says that workers getting paid through IHSS are not covered under the Domestic Workers Bill of Rights. So arguably, even the hours you work for me, because we're all joint employers, the Domestic Workers Bill of Rights does not apply. There can also run into problems. I believe IHSS doesn't like it when you pay them to do extra work, particularly if it is work that you have, that IHSS is paying for. And you may lose benefits, either under Medicare or other programs, if you're hiring somebody to do those services. Because if, for example, IHSS is paying somebody to come in and bathe you, and now you are paying somebody else, you're paying that person separately to bathe you as well, then IHSS could say, well, we're not going to pay you for that because you're already paying for that separately. You have funds for that. So the way we've done it in the past is we differentiate between these are the services you're doing for IHSS. These are your IHSS hours. You're reporting those to IHSS. These are the hours and duties you're doing for me. You're reporting those to me separately. They're completely separate. We don't really know what the court's going to do with that. It's kind of the best case scenario we can do is just have a clear delineation between the two.
Okay. Is it a problem if we let a caregiver live in our home rent-free instead of paying them?
Yes, it's a very big problem. You have to pay minimum wage and overtime to all employees. There are times when you can use room and board to offset your minimum wage obligations, but it's very limited. Number one, you have to have a written agreement. Number two, the wage order specifies the amount that you can deduct as against your minimum wage obligations. And it's a very small amount. It's around $60 to $70 per week for rent if they have their own room. It's nowhere near fair market value. So you'll never be able to do a direct, you're going to work for us for free and you're going to stay here for free. You can do a small deduction. It's usually not worth the amount of effort that you have to go through to do that deduction because you have the written agreement. It's such a small amount. The calculations get weird and difficult. What you can do is you can have two separate transactions. I can rent you space in my home and have a rental agreement, and I can hire you to perform work for me. And those are two separate transactions. I pay you as an employee. I'm taking out taxes. I'm paying you for the work. You are paying me as a renter, and I'm claiming that rental income on my taxes. Sometimes that works, sometimes it doesn't. Can't be just a charade or a sham, but that's probably the closest way you can do it.
Okay. If a worker is driving a beneficiary in their own vehicle, what are they? Independent contractor or employee?
So generally speaking, I would say that they are your employee. They're more likely going to be a chauffeur because they are performing service. They're not fitting under one of these exceptions. Now, the ABC test doesn't fit really well in the caregiver situation because the people they're providing care to are not in any type of an occupation. But I think a safer bet is to assume that they are an employee unless that person is in the business of providing those services to elderly. There are companies that provide transportation services. So if the person has a business license, they have insurance, they have multiple clientele, they're advertising, they're having a written contract, then we might see a situation where, okay, this can be an independent contractor because they have their own business. If, on the other hand, no, this person that's just part of the duties that they're doing as a caregiver as well, then they're more likely not going to be an employee. So, again, if it's an occasional service that they're using, it can be regular. It can be once a week that we're going, or maybe even once a day, but they're providing services to other people. I feel more comfortable as long as they have that business license, they're advertising outside.
Okay, well, in terms of paying them, do you just pay them for like the mileage, or can you pay them mileage plus?
So you pay them for mileage or mileage plus. So if they're your employees, you have to pay them for the hours that they're working, and that may be the time that they're just transporting you, or it may be the time that they're also waiting for you. So if I hire you to drive me to the doctor and wait around until I'm ready to be picked up and then drive me back home, I have to pay you for that whole time if you're an employee. If you're using your vehicle, I also have to reimburse you for the use of your vehicle. The easiest way to do that is to use the IRS standard mileage rate. If you're an independent contractor and you truly are, you have your own business, I can hire a limo service to come pick me up. Or I can hire Uber or Lyft or a version of that, and they have their own business. If it's that type of a model, then it's up to your contract, you as the driver, to dictate how you're going to charge me. You're probably going to charge me a flat rate or a piece at a mileage rate, however it's going to be.
And how does that change if the caregiver or the driver is using the beneficiary's car?
I think it's more difficult to claim that somebody is an independent contractor if they're driving my car. It might be one thing for me to hire a taxi or an Uber or a limo service to drive me a place. It's another thing for me to hire you to come drive my vehicle. First of all, you have to make sure that the person is a licensed driver, has they're going to be covered under your insurance to drive you. I would either bring that person on as an employee because they're using your vehicle, you're now controlling the instrumentalities of the work, or I would hire an outside service that provides all their own equipment, their own vehicles, etc.
Okay, here's a question I'm not 100% clear on, but I'll ask it anyways. What if a volunteer gets injured, for instance, helping the beneficiary transfer from a bed to a wheelchair?
Okay. So what happens with volunteers? First of all, understand that under California law, volunteers are pretty rare. According to the Labor Commissioner, you can only really be a volunteer if you're doing work for a nonprofit, a 501c3 or other charitable organization. Otherwise, you're not a volunteer. Now, having said that, there are situations where the neighbor might come over and help out with something, and that might be an occasional thing. If it was truly an occasional thing, then they may, in fact, just be being a friendly neighbor. If it's you're a volunteer in that I'm not paying you, but you're going to come over every day for 2 hours to cook food and help somebody out, that's really an employee. Your homeowner's insurance may cover a slip and fall or an injury. Most people don't realize that even if that person is deemed to be an employee, your homeowner's insurance may cover some of those injuries. My recommendation is if you're going to have people coming into your home to provide services, you get the workers' compensation rider on your homeowner's policy to ensure that that's going to be covered. But it's likely it's going to be something that would be covered under the homeowner's insurance, possibly under workers' comp, depending on if they really are in fact an employee or not.
Okay, you mentioned about the security guard not being able to leave their post.
Mm-hmm.
What about a caregiver that cannot leave a beneficiary because they can't be unattended? Then how do you handle lunch breaks and lunches and things
Well,
like
caregivers, actually personal attendants, under wage order 15, which is the wage order for household occupations, personal attendants are exempt from the meal and rest break periods. And the Domestic Workers Bill of Rights doesn't give them a right to meal and rest breaks. So actually, caregivers are one of the few people that you don't have to give rest and meal breaks to. Now, my contracts still tell them, hey, we want you to take breaks, and you should take breaks whenever you can. But they're actually the one, if they really are a personal attendant, where you don't have to give them rest and meal breaks. Now, let's assume for whatever reason they're not really a personal attendant. Maybe they're actually a chef or a chauffeur. They don't meet that exemption, such that they do get meal and rest breaks. And you just can't afford to give them. You need that person to be there. Then you pay them for that time, and you pay one additional penalty. Technically, you pay 2 one-hour penalties, one for the rest breaks and one for the meal breaks every single day.
that? Okay. I think that's the end of our questions.
The end of the questions.
Okay, well, thank you very much. I appreciate those are really good questions. If you have other questions, you can certainly feel free to reach out to me. Do we have any closing remarks?
Well, let's see. Just to have some closing remarks here, and assuming that I am on camera here. Anyway, Robert, I learned a lot. I didn't exactly like all your answers as the trustee, but apparently that's not your job here. So that was really helpful.
Thank you.
For those of you that are watching here, once again, make sure that if you're interested in credit for this, that you email amy@gspt.org. For this and other programs. I think at this point we have about 15 hours of programs in the can. We've got a bunch coming up. So with that, I want to thank you very much for watching today. And Robert learned a bunch. And once again, if you can, DJ, if you can put up his information here, if you have any questions here, especially if there are employment issues, once again, certainly call Robert. I'll give you a guess, but he'll give you the right answer. Okay? Thank you very much. And with that, happy advocating and good night.